Hey, young people. Well, George Floyd, closing arguments. This should be interesting. So the judge is going to give them some, I guess, law, or I don't think he's going to do the jury instructions right now, but I think he does that afterwards, but we'll see. So here we go. Closing of George Floyd case. Closing arguments, then it's given to the jury, and we're waiting for a verdict.
Your chair so that you can listen to the closing arguments of counsel. So members of the jury, I instruct you as follows. It is your duty to decide the questions of fact in this case. It is my duty to give you the rules of law that you must apply.
Okay, so here's where juries, again, get confused between doing what's right and doing what the judge tells them to do. And that's what the jury is supposed to do, is to do what's right. But a lot of times the judges will intimidate them into following the so-called law, which really isn't law, depending on who you are and depending on how you interpret each word of the law and who gets charged and who doesn't. So the law really doesn't matter, but jurors sometimes try to follow the judge's instructions.
In arriving at your verdict. You have now heard the evidence, and soon you'll hear the arguments of counsel. At this time, I will instruct you in the law applicable to this case. You must follow and apply the rules of law as I give them to you, even if you believe the law is or should be different. You have each been given a copy of these instructions to follow along as I read.
Even if you believe the law should be different. He's trying to cover jury nullification, saying that it's illegal for jurors to find not guilty even though the law's wrong. And that's incorrect. Jurors can absolutely do jury nullification and say the law's bullshit, this trial's bullshit, and I ain't voting for the government. So don't believe that crap.
Read, and you may take your copy with you when you retire to the jury room. Nevertheless, you should listen carefully and attentively as I read them to you now. Please note that the titles of the individual sections of these instructions are not a part of the instructions, but merely placed as headings to assist you in finding a topic. Deciding questions of fact is your exclusive responsibility. In doing so, you must consider all the evidence you have heard and seen in this trial, and you must disregard anything that you may have heard or seen elsewhere about this case. I have not, by these instructions, nor by any ruling or expression, to disregard it. You must consider these instructions as a whole and regard each instruction in light of all the others. The order in which the instructions are given is of no significance. You are free to consider the issues in any order you wish. The defendant is presumed innocent of the charges made. This presumption remains with the defendant unless and until he has been proven guilty beyond a reasonable doubt. The fact that the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you in any way suggesting guilt. The burden of proving guilt is on the state. The defendant does not have to prove his innocence. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. A fact may be proven by either direct or circumstantial evidence, or by both. The law does not prefer one form of evidence over the other. A fact is proven by direct evidence when, for example, it is proven by witnesses who testify as to what they saw, heard, or experienced, or by physical evidence of the fact itself.
Did you hear that? Witness testimony is direct evidence, even though it's the most unreliable evidence out there.
A fact is proven by circumstantial evidence when its existence can be reasonably inferred from other facts proven in the case. For example, if a person watches deer crossing a snow-covered field, the person has direct evidence of deer walking in the field because the person sees it. If the person does not see deer but finds deer tracks in the snow, the deer tracks are circumstantial evidence that deer walked in the field because that factual conclusion can reasonably be inferred from the tracks found in the snow.
Like if a person is taking drugs, fentanyl, methamphetamine, has a heart condition, has high blood pressure, is not taking his meds, fighting with the cops, and eating drugs, that can infer that he put his own life in danger.
Now, attorneys are officers of the court. It is their duty to make objections they think proper and to argue their client's cause. However, the arguments or other remarks of an attorney are not evidence. If the attorneys or I have made or should make any statement as to what the evidence is that differs from your recollection of the evidence, you should disregard the statement and rely solely on your own memory. If an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement.
So that means you can kind of pretty much ignore what the attorney says and make up your own mind.
The state has brought 3 charges, or counts, against the defendant. Each count charges a separate and distinct offense. You must consider the evidence applicable to each count as though it were the only accusation before you for consideration, and you must state your findings as to each count in a separate verdict, uninfluenced by the fact that your verdict as to any other count or counts is in favor of or against the defendant. The defendant may be found guilty or not guilty of any or all of the offenses charged, depending on the evidence and the weight you give it under the court's instructions. I'm about to instruct you on the law that you are to apply to the charges in the defense, but before doing so, I am going to define a few words and phrases that appear more than once in the elements of the charges and the defense that follow. The words and phrases being defined are bolded in the written copy of the instructions you will be receiving. You should use these definitions for these words and phrases in your deliberation. Attempted means that the defendant did an act which was a substantial step toward and more than mere preparation for causing the result, and that the defendant did that act with intent to cause that result. There are several...
Who thinks Chauvin intentionally tried to kill or cut off his heir and make George Floyd die? I mean, no reasonable person can think that. Now, if you're unreasonable and it's all about color, then you absolutely can believe that.
Several forms of bodily harm relevant to some of the charges or the defense. Bodily harm means physical pain or injury, illness, or any impairment of a person's physical condition. Substantial bodily harm means bodily harm that involves a temporary but substantial disfigurement, that causes a temporary but substantial loss or impairment of the function of any bodily member or organ, or that causes a fracture of any bodily member. Great bodily harm means bodily injury that creates a high probability of death, that causes serious permanent disfigurement, or that causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. To cause death, causing death, or caused the death means that the defendant's act or acts were a substantial causal factor in causing the death of George Floyd. The defendant is criminally liable for all the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were the natural result of the defendant's acts.
Somebody repeat what he just said and explain it. I mean, this is the problem, man. They get in here and they make things so complicated and so convoluted that the reasonable person, non-cop, non-lawyer, is confused. And it's like, well, I'm not sure what that meant, and should I do this? And should I, you know what? You should just either be able to say the government proved clearly, without a doubt, that this happened. And if they didn't, or if you think they hid or lied, then vote not guilty. I mean, no, not guilty should be the default for every juror. I think they ought to tell everybody, you're obligated to vote not guilty unless the state proved their case and convinced you without a doubt. But you can't say without a doubt because it's without a reasonable doubt.
The fact that other causes contribute to the death does not relieve the defendant of criminal liability. However, the defendant is not criminally liable if a superseding cause caused the death. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not otherwise have occurred.
like taking drugs, like not taking your high blood meds, like fighting with the police, like resisting arrest, like those things?
To know, to have knowledge, or knew requires only that the defendant believes that the specified facts exist. Intentionally or intentional means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal, and that are set forth after the word intentionally or intentional. With intent that, with intent to, or intended, means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause that result. It is not necessary that the defendant have this intent in advance. The necessary intent can develop during the commission of the act. Police officer means an employee of a law enforcement agency who is licensed by the Board of Peace Officer Standards and Training, charged with the prevention and detection of crime and the enforcement of the general criminal laws of the state of Minnesota, and who has the full power of arrest. A law enforcement agency is a unit of state or local government that is authorized by law to grant full powers of arrest and to charge a person with the duties of preventing and detecting crime and enforcing the general criminal laws of the state of Minnesota. The Minneapolis Police Department is a law enforcement agency for these purposes. The definition of any word or phrase with a specific...
I'm sitting here watching this and recording it, and I already tuned out, and I really did not even hear what he just said. The last thing I heard was their law enforcement agency. And I'm not on the jury, but I'm just sitting here, and I've already got worded out.
Legal meaning that appears only once in the elements or the defenses will be defined where it appears later in these instructions. The defendant is charged in count 1 with murder in the second degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another without intent to cause the death of any person, while committing or attempting to commit a felony offense, is guilty of the crime of murder in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the second degree while committing a felony are: first element.
You notice how he's trying not to inflect on words? I mean, if attorney hears the judge say, if it looks like the judge is skewed in trying to either help the defense or the defendant, the prosecution will object and can kind of either appeal or make a complaint on the judge because he inferred that he either wasn't guilty or he was guilty. So you notice that he's trying to be very monotone and not give any inflection to any word so he doesn't set up a complaint or, somebody can say that he was being biased.
The death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant at the time of causing the death of George Floyd was committing or attempting to commit the felony offense of assault in the third degree. It is not necessary for the state to prove the defendant had an intent to kill George Floyd, but it must prove that the defendant committed or attempted to commit the underlying felony of assault in the third degree. There are two elements of assault in the third degree. First, defendant assaulted George Floyd. Assault is the intentional infliction of bodily harm upon another, or the attempt to inflict bodily harm upon another. The intentional infliction of bodily harm requires proof that the defendant intentionally applied unlawful force to another person without that person's consent.
Unlawful force. See, this is kind of confusing because if you think about it just to what he's reading, it says, if you try to hurt somebody. Well, the cop tried to hurt him. He put his knee on him. But it was lawful, consistent with his training and policy and with what he was trying to do. George Floyd tried to hurt the cops. He was trying to get away. He was trying to pull away. He kicked at the cops. So you can meet that force with greater force, and a lot of people don't get that.
And that this act resulted in bodily harm. Second, defendant inflicted substantial bodily harm on George Floyd. It is not necessary for the state to prove that the defendant...
I notice that Chauvin does not look at the jury a lot, and I don't know if that's good or bad. If he looks at him and he gets eye contact and he looks away, the guy he got eye contact with could say, oh, he looked away, he's guilty. But if he stares at him, he said, oh, he's staring at me, he didn't look away, he's trying to intimidate me. So looking at the jury is an iffy thing. And I've noticed that he's almost intentionally always writing, always looking down, always acting like he's doing something, so he doesn't necessarily have to look at the jury. Not to mention that because his face is covered, they can't attach with him. There's a thing, you know, in law enforcement to where when crooks and criminals mask their hostages, the likelihood of them killing them goes up extremely high because they don't connect with them as a human. They don't see their face. So if you're ever a hostage and they cover your face, you better start planning to do something because they're probably going to kill you. And so when these guys are wearing masks, he can't identify with the jury can't see his facial expressions. I think that's a hindrance. I mean, it may even be appealable. I think it'd be a brilliant appeal, but we'll see.
Defendant intended to inflict substantial bodily harm or knew that his actions would inflict substantial bodily harm. Only that the defendant intended to commit the assault and that George Floyd sustained substantial bodily harm as a result of the assault. Fourth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge.
Now you're going to hear reasonable doubt in these closing arguments that the prosecution always gives the same little speech. They just use different words. Reasonable doubt is not no doubt. I mean, it's reasonable. And, you know, and they'll give some example and, you know, that's reasonable, and they'll always use the term, this isn't TV, you know, this isn't CSI to where we can file. And they found that jurors like the CSI type convictions. They're more likely to convict when you have good DNA or scientific evidence. But if you don't have a lot of that, then they're not as likely to convict. So the DA will always try to get in there. This isn't TV and we can't prove it like they do. We know there's going to be some doubt. I mean, there's always some doubt. What's certain in life, blah, blah, blah. So they always get them to they want to lower the bar for reasonable doubt.
If you find that any of the elements have not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons according to the instructions below that are listed on page 8 under the heading Liability for Crimes of Another. The defendant is charged in count 2 with murder in the third degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life, but without intent to cause the death of any person, is guilty of murder in the third degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the third degree.
This is the one that I think that jurors are most likely to kind of give the benefit of the doubt and find him guilty. Because it takes out, even if he doesn't intend to cause it, but he was kind of like aided and abetted. This is the one where the drug dealer could get charged because he gave the drugs. So this is kind of a easy peasy kind of way to get somebody charged with murder. And this is where I think the jury may just default to, well, you know what? It's probably not first, maybe it's second, but for sure it's third.
Our first element, the death of George Floyd must be proven.
Okay, that's easy. First element is completed. George Floyd's dead.
Second element, the defendant caused the death of George Floyd.
I don't think that's proven. There's no way you can convince me without a doubt that Chauvin caused the death of George Floyd with all his medical issues, drugs, fighting, and all that. I don't think that element is proven. But will the jury think that?
Third element, the defendant caused the death of George Floyd by an intentional act that was eminently dangerous to other persons.
I think the jury will think that element's proven because he put his knee on him. But I don't think it's proven because he was doing it approved by the agency. All cops do it. A lot of cops do it, and a lot of people don't die. Cops are trained that way. A guy did an interview. Stephen Crowder did an interview with a guy kneeling on his neck, and he didn't die. So I don't think they've proven that one. But as a jury, I think they're going to see it as he put his neck. He should have known it would have killed him. So this is where it's up to the jury.
A person commits an act eminently dangerous to others when the act is highly likely to cause death. Fourth element. Defendant acted with a mental state consisting of reckless disregard for human life.
I think they might be able to say that element's proven. I think he was reckless. I think he didn't check his pulse, and he didn't give medical aid. So I would say that element is proven. But you got to prove all the elements.
The defendant's act may not have been specifically intended to cause death, and may not have been specifically directed at the particular person whose death occurred, but must have been committed with a conscious indifference to the loss of life that the eminently dangerous act could cause. Fifth element. The defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements
Obviously, the fifth element's proven.
has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven
Absolutely should be not guilty because he did not prove beyond a reasonable doubt that Chauvin caused his death. He should be not guilty. I'm sorry. Go ahead and riot and call me a racist.
beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the instructions that are listed on page 8, under the heading Liability for Crimes of Another. The defendant is charged in count 3 with manslaughter in the second degree in connection with the death of George Floyd. Under Minnesota law, whoever by culpable negligence, whereby he creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another person, causes the death of another, is guilty of manslaughter in the second degree.
Okay, so from the title, it sounds like he's guilty because he did actions. But unfortunately, he did those actions sanctioned by law, has a law enforcement officer that he's approved and authorized to do to overcome the resistance of the person fighting him. And they don't really say that.
The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of manslaughter in the second degree are: first element, the death of George Floyd must be proven.
Okay, we've proven that one. First element's good.
Second element, the defendant caused the death of George Floyd by culpable negligence.
Whoa. That's a maybe. Let him finish here.
Second element, the defendant caused the death of George Floyd by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm.
I don't know. I think most juries will say that element's completed. I'm not sure. I would agree with that. I'd have to think on that one. It's close.
Culpable negligence is intentional conduct that the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others.
Okay, so that's misleading because officers are not judged on what a reasonable, prudent person would do. They're judged on what a reasonable, prudent officer with the same training and experience. The Supreme Court have made that clear. You can't judge officers with their training and tools because they're fighting and going into these situations. You can't judge them the same way as a citizen that doesn't have to go into these situations. So that's a little misleading on that element, in my opinion.
Third element, the defendant's act took place on or about May 25th, 2020 in
Okay, we know that's element's good.
Hennepin County. If you find that each of these elements
So there's only 3 elements, and one's that he died, and one's that the act took place on this day. So those 2 are done. The only one that they really have to do on this charge to figure out is, was his acts negligent for a reasonable person? And it ought to be no, because it's for a reasonable officer and not a reasonable person with the same training and experience. Hopefully someone on the jury will remember that, but we'll see. And hopefully in the closing arguments, he will make sure and clear that up. See, he knows what the elements are. In his closing arguments, he's going to try and convince the jury that the elements aren't met and that it hasn't been proven. And the prosecution is going to say, here's how we proved it. Here's why you should find him guilty. We know he did this. We know the doctor said this. We know this expert said that. And they're going to try to prove the elements were done.
has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the following instruction on liability for crimes of another. The following instructions apply to all three of the charges I've just given you. The defendant is guilty of a crime committed by another person or persons only if the defendant has played an intentional role in aiding the commission of that crime and made no reasonable effort to prevent the crime before it was committed. Intentional role includes intentionally aiding, advising, hiring, counseling, conspiring with, or procuring another to commit the crime.
See, the jury may think that because he used other officers to help him, he's done this. I would say he tried to use lesser methods when they put him in the car, and George Floyd caused this because of his resistive actions, not because the officers wanted or tried or made this happen.
The defendant's presence or actions constitute intentionally aiding only if first the defendant knew another person or persons were going to commit or were committing a crime. Second, the defendant intended that his presence or actions aid the commission of that crime. If the defendant intentionally aided another person or persons in committing a crime, or intentionally advised, hired, counseled, conspired with, or otherwise procured the other person or persons to commit it, the defendant is also guilty of any other crime the other person or persons commit while trying to commit the intended crime.
While trying to commit the commit and committed, and then they committed the crime of the commit of the commit. Did you get that?
If that other crime was reasonably foreseeable to the defendant as a probable consequence of trying to commit the intended crime.
So, probable consequence of the intended time that he tried to commit, assisted in committing with the committing commit. I got it.
The defendant is guilty of the crime under this theory of intentionally aiding in the commission of a crime by another person or persons only if the other person or persons commit the crime. The defendant is not guilty for aiding, advising, hiring, counseling, conspiring, or otherwise procuring the commission of one of the charged crimes unless that crime is actually committed. The defendant, or the state rather, the state has the burden of proving beyond a reasonable...
Whoa, man. He should have cleared that up good. He immediately said defendant, and then he said the state. Man, that was a bad mess up.
Defendant, or the state rather, the state has the burden of proving beyond a reasonable doubt that the defendant intentionally aided another person in committing the charged crime. No crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody.
That pretty much ought to settle it right there. Did you hear that? Let's listen to that again.
A police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody, committing the charged crime. No crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody.
So, the question here is, was it reasonable? Because you had some career cops and the black chief that came in and said it wasn't reasonable. And you had other experts that say it was reasonable. So, that's kind of the question on this. Was he a cop and was he being reasonable? Me personally, I think he was pretty reasonable, except when a guy stopped breathing, he didn't check his pulse, and he didn't roll him over or try to take steps to save him. I think he was reasonable up to that point, but when he stopped breathing, he was already dead, and he was reasonable at that point. So then it gets into, well, if he had tried to save him, maybe, if and buts and coconuts, he could have saved him if he started earlier, but we don't know all those drugs in his body. I mean, you just can't prove that, to me, you can't prove that he did it, is his fault, and everyone else, and no medical issues, no drugs, no crime, no resisting arrest, nothing else matters. It's just him. I just don't get there. Sorry.
The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer, and without regard to the officer's own subjective state of mind, intentions, or motivations. The defendant is not guilty of a crime if he used force as authorized by law. To prove guilt, the state must prove beyond a reasonable doubt that the defendant's use of force was not authorized by law.
Okay, so it sounds like he is reading the jury instructions, but what I remember and how we used to do the jury instructions, and I don't know if it's different now, is we would have these sheets, and each jury instruction was on a separate page, and it would say, what is force? What is intent? What is this? And it sounds like almost he's reading those, but they're not on separate pages, and he's not really putting the headings. And he talked earlier about there's headings, and maybe that's what he was talking about. Because when I remember jury instructions, there were a lot. And I mean, it was crazy. Like, what is burglary, and what is forcible, and what is intent, and what is assault, and what is a deadly weapon, and what is reasonable, and what is... And I mean, it sounds like he's covering all that, but I just remember them all being on separate pages, and there was a lot of them. So maybe he just put them all in one document, because these flipping pages covered a lot of them.
You are the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. In determining believability and weight of testimony, you may take into consideration the witness's interest or lack of interest in the outcome of the case.
And I think that's pretty clear. On some of them, I think when someone's not interested in the outcome, they're more credible. And when they are interested, they're less credible. And the prosecution witnesses were all had his best interest. They were, I don't think there was one non-biased, well, maybe there was one or two that I said that did pretty good. That one clerk, the young black kid, I think he's 17 or 18, that was a clerk. I thought he was pretty credible. And I think that one female was pretty credible. Sorry, my thing froze up and I had to refresh it, so I think I'm at the right spot.
That the defendant's use of force was not authorized by law. You are the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. In determining believability and weight of testimony, you may take into consideration the witness's interest or lack of interest in the outcome of the case.
Wow, it froze again. What the hell? Something happened. I don't know what happened. Froze up. Okay, it starts up here in a second.
The case, as you find them, you should disregard the chart or summary or animated video and determine the facts from the underlying evidence. Earlier during these instructions, I defined certain words and phrases, and you are to use those definitions in your deliberations. If I have not defined a...
Okay, so this is the jury instructions for sure. I mean, we'll go from there.
Word or phrase, you should apply the common, ordinary meaning of that word or phrase. During this trial, I have ruled on objections to certain testimony and exhibits. You must not concern yourself with the reasons for the rulings, since they are controlled by rules of evidence. By admitting into evidence testimony and exhibits as to which objection was made, I did not intend to indicate the weight to be given such testimony and evidence. You are not to speculate as to possible answers to questions I did not require to be answered. You are to disregard all evidence and statements of attorneys that I have ordered stricken or have told you to disregard. And with that, I'd ask you to put your instructions under your chair as we listen to the closing arguments of counsel. Is the state ready to proceed with closing?
Yes, sir.
Mr. Slisher, you may proceed.
Okay, so I'm going to make this a separate video and do a closing, make the prosecution and the defense separate videos for their closings.